to A and his offspring, to A and his family according to seniority. You could also use the word to A and his issue, and to A and his posterity. Now, what this one is saying is that in creating an entailed interest, by will, the Wills Act is applying to say that less formal language will create very less formal language will create an entailed interest. It will create an entailed interest in a will than a deed. And it's saying that any expression indicating an intention to give the device as an estate of inheritance descendable to his lineage as distinct from his collateral heirs would confer an entailed interest upon it. Therefore, if you use anything like A and his seed, A and his offspring, A and his family according to seniority, A and his issue, A and his posterity, would grant a fifth-tail estate to you under the Wills Act of 1837. I'm not sure whether you understand what I'm saying. Did you get the
Sir,
point?
please, what section of the Wills Act is that?
This section 28.
All right, thank you, sir.
Yes, sir. Are we together?
So I have a question, sir.
Yes, please do.
My question is, as regards the amendment made by Wills Act, it says that A and his seed, A and his offspring, it can suffice. But for fee simple estates, some of the amendments made, they said that we could use A and his heirs and X in fee simple. So what's now the difference? If it's still going to their heirs, still going to their offspring, so what's the difference between the fee simple and the fee tail? Is it just because for fee tail there's like a female part of it or the male part of it? I don't understand the difference exactly, since the words have been amended.
No, please listen again. You see, there are two things attached to estates. How it is created and who can inherit. How it is created and who can inherit it. How they create fee simple is that it has to be to A and his heirs. Are we together? Under the common law. Are you getting my point? Hello?
Yes, sir.
Are you there?
Yes, sir.
Who can inherit? Who can inherit fee simple? Who can inherit? Tell me, who can inherit? Can you tell me?
Sir, to A and his heirs. So it's going to be the A himself and his descendants.
No. It means that if it is to A and his heir under the common law and you are creating fee simple, it means that the descendant can inherit, the ascendant can inherit, and the collateral relatives can also inherit. So that's why I'm saying that it depends on the kind of estate you are creating and who's going to inherit that will determine the words that will be used and the effect of the amendment that is being made. Now, under the common law, fee simple means that everybody can inherit. The parent, grandparent can inherit. The children can inherit. The brothers and sisters, cousins, they can also inherit. That's what fee simple suggests. Are you getting my point?
Yes,
now,
sir.
Common law says that if you want to create a fee simple, you must use those words strictly as to A and his heirs. Are we together? If you don't use to A and his heirs, what you will have ended up creating is a life estate, whereas your intention was to create a fee simple estate. Now, the amendment that is made by Wills Act in respect of wills, amendment made by Conveyancing Act in conveyancing state, and then PCL in PCL state, is not affecting who can inherit, does not affect who can inherit. It's only affecting how you can create it. It's only affecting how you can create it. Words that you can use to create it. They have created more rooms they have enlarged the room to make it possible for you to create fee simple in a particular way that common law has not allowed. They do not affect who could inherit or who could not inherit. So under the common law, the person that will inherit in the fee simple, they are collateral, relatives, descendants, or ascendants. Now, under the in fee tail, who could inherit is only the descendant. That is the linear issues of the grantee. So the amendment made by Wills Act, as it affects the fee simple, is that any word that you use in trying to make a bequest of a fee simple in your will, it will pass as fee simple. It doesn't matter how you describe it, so long as what you have is fee simple, then fee simple will be granted. So you don't necessarily have to use the word to A and his heir to grant fee simple in making a will under Section 28 of Wills Act, since it has come into inception. So now, since that's come into being, rather, now it goes further to say that when you are creating, so what that means that if you have a fee simple and you want to give it under the will, whatever word that you use, without necessarily using to A and his heir, it will pass as fee simple. Therefore, your ascendant can inherit, your descendant can inherit, your collateral relatives can also inherit. But it's saying that the amendment made by Wills Act and the statute, they are not changing who can inherit. They are not changing who can inherit. They are just telling you that you can be more flexible. We can allow you to use more flexible words in creating an estate. So if you are creating an estate, or you are granting an estate in your will, you don't have to use the word to A and his heir to create fee simple. You don't have to use the word to A and heirs of his body to create what? To create, a fee tail bequest in your will. So it's saying that as far as Wills Act is concerned, as far as the amendment made by Conveyancing Act is concerned, as far as the amendment made by PCL Act is concerned, to fee simple creation, to fee tail creation, are we together? You can use, they have allowed more flexibility in the words that you can use to create them. They are not changing the category. The amendment made by the Act are not changing the category of people who can inherit. It's not changing the category of people that can inherit. So look at the word. It says when creating fee simple, in creating an entailed interest by will, the Wills Act apply so that less formal language will create an entailed interest in a will than a deed. Any expression indicating an intention to give the device as an estate of inheritance descendable to its linear as distinct from its collateral heirs would confer an entailed interest upon him. I'm not sure you're getting the point I'm making. Did you get the point I'm making?
Sir, yes, I do understand. So you're just trying to say that fee simple estate goes for the descendants, the ascendant, and collateral family. It's just that the Act, they just made some amendment as to how you can create them and make them more flexible.
Fantastic.
Okay. And that's the same goes for fee tail too.
Fee tail, which is limited to
it's limited to just the descendants. Okay,
and
that's
then
fine.
So the Wills Act, the Conveyancing Act, and then the PCL only made more flexible the way you can create or you can grant fee tail.
I do understand.
They did not affect the category of persons that can inherit under the tool estate. So they are just making it more flexible. The flexibility of Conveyancing Act is just to say you can create fee simple by saying in fee simple or to A and heirs. Whereas the PCL is saying that we allow more flexibility by virtue of Section 85 sub 1. You can say to A or to X forever, or to A and his heir, or to A in fee simple. Anyone that you use, in fact, just like the flexibility that is allowed under the Wills Act is the same flexibility that is allowed under the PCL when creating any of those estates. That's the point we are saying. Are we together?
Yes, thank you very much, sir.
Okay. So, okay.
Sir, sorry, I have a question.
Yes,
When it
please do.
comes to creation of fee-tail for deeds, the Section 28 of Wills Act, does it also apply?
Yes, now that's the rule. That's the law applying to us. Yes.
For deeds,
Okay.
not wills, for deeds.
No, which act does not apply to deed now? You didn't get it. Which act apply to when you are making a will? You know, you can grant something by will. You can grant something by deed. Are we together? Hello? Hello?
Yes, sir.
You
Yes,
can make
sir.
a grant. You can make a grant in form of a bequest or device by will. Okay. You can also make a grant by deed. So when you are making a grant or a device or a bequest by will, what will be applicable is the Wills Act. So if what you want to grant is by means of deed and you are in a PCL state, what will be applicable in that grant is the PCL, Property and Conveyancing Law. It's the provision of PCL. So if you are in the Conveyancing Act state, and want to make the grant by deed, what will be applicable is the CA, that is Conveyancing Act of 1881. But if you are doing that, if you are doing it by will, the provision of the will be applicable. So trying to recap what I'm saying that now you have an estate. Your estate is fee-tail, and then the fee-tail is saying that it can be inherited by ascendants, descendants, and collateral relatives. That is what the provisions of that's what common law provides for in fee simple. Now, the Wills Act or the CA or the PCL in their amendment, they did not affect who can inherit. They only made changes as to how you can create the fee simple or fee-tail. Therefore, if we are talking about will, PCL and CA will not be applicable. If you are making a grant to somebody in your will, you are making a bequest or device of land to somebody in your will. If what Wills Act is saying is that if what you have is fee-tail, you don't have to comply with the words of limitation imposed by the common law. Whatever word that you use there to express that I am giving my fee-tail to so person, fee-tail will pass to that person. Fee-tail will pass to that person if what you have is fee-tail. Now, if what you have is fee simple will pass to that person irrespective of any word that you use to describe that fee simple in your will. Now, they now say that if you are going to make that grant by deed, the flexibility we are going to be applying, or the flexibility that we are going to allow for you, if you are in the Conveyancing Act state, is as good as saying that I make this, I give this to A in fee simple, or I give this to A and it's yes. Those are the two flexibilities allowed for you in creating a grant of fee simple under the Conveyancing Act by virtue of Section 52. Now, Section 85 sub 1 of the PCL now says that if you are making a grant by deed, we could allow you to use any variant that will give an interpretation or give an impression that what I'm giving out, which I have, is fee simple. If I have fee simple, I can say to X, I can say to X forever, I can say to X and his A, and I can say to A to X in fee simple. Any of those words that you use, any of those language that you use will qualify to in creating a fee simple. Unlike the common law that is so rigid, so harsh, so difficult, and cannot be turned around. You can't change it. It says it has to be to A and its heirs. So what I'm trying to say is that it is the difficulty created by common law that Wills Act in Section 828 had actually amended, had actually stopped in. Now, the Wills Act or the Conveyancing Act, they apply to deed, any grant that you make by deed. That is what Wills Act will that is what Conveyancing Act will deal with any in the Conveyancing Act state, and then if you make any grant that has to do with fixed input in a PCL state like Osun, Ogun, Oyo, Ondo, Ekiti, Delta and Edo, then the PCL rules of how to create the fixed input will apply. The two of them, either the Conveyancing Act, the PCL, they don't change what you are likely to get if you are devising, if you are giving out, if you are granting fixed input or if you are granting fixed tail. Never forget that the interest that is inheritable, the people that can inherit under the fixed input include the descendant, ascendant, and collateral relatives, whereas the people that can inherit under the fixed tail include only the linear descendants, the linear issues, the descendants. So the Wills Act, the Conveyancing Act, the so-called PCL, they are not changing who can inherit. They are only telling us that we could be more flexible in creating or granting that estate, be it fixed tail or fixed input. I'm not sure whether I'm making any point. Hello, guys. Hello.
Yes, sir, we can hear you.
Yes, sir, we understand. Yes, sir.
Okay, so I shouldn't have a problem in the exam if I ask you. I shouldn't. Is that an assurance that I will not have problem with you if I ask you in the exam? You don't want to talk? Okay.
Yes, sir.
We hope not, sir.
Okay, no problem. I know that. Don't worry. With time, if you have not understood anything, just go back home again, try to study, and then if you come back to the class again, I don't mind going to start from the beginning again, so that you can understand it. Are we together? Hello?
Yes, sir.
Yes, thank you very much, sir. Yes,
But
sir.
I forgot to tell this class that an approach to any exam, an approach to any course is never get scared. Don't get scared. Land law is just like any other course. In fact, I don't consider any course difficult. It is your approach to it that makes it difficult. If you come to class with a mindset that I want to know it, I want to listen to the teacher. If the teacher is teaching me and I don't understand, please stop the teacher. Let him explain to you. And then after the teacher has explained to you, do your own part. Go back, read it very quickly, make some jottings, and then if you have any problem after that, when the teacher comes back to class again, ask him the question. He will explain. He's been paid. We've been paid fantastic sum of money to teach you. So it's our job to teach you. When you have any problem, you have any difficulty, ask us. We stand in the position to explain to you over and over. And I tell you that I have that obligation towards you, and I will fulfill that obligation, in respect of this course. And I pray that all of you will have a better understanding and will earn good mark at the end of it. So we'll meet again by next week Monday. Is that clear? Is that correct? Is that hello?
Yes, sir.
Hello? Okay. So
Sorry, next
Monday at
Tuesday, sir.
Monday at
Next week.
11 o'clock. Monday at 11 o'clock, Abi.
No, Tuesday, sir.
No,
sir.
sir,
Next
Tuesday.
week, Tuesday.
Sorry. Okay, Tuesday at 11 o'clock. Then
Yes.
Thursday at 12:30. Okay, thank you. All right.
All right, sir. Thank you so much. Bye-bye, sir.
Thank you, sir. Thank you, sir.